I am Lee Liberman Otis, one of the senior vice presidents of the Federalist Society and the director of our faculty division. And I'm delighted to welcome all of you to the 26th Annual Federalist Society Faculty Conference. Great to see everybody here, and looking forward to a terrific conference. Before we get started, I wanted to first say that I'm sure that everyone here is thinking about our fellow, our friends and others in Los Angeles, and that our hearts are going out to the people who are going through that. It's a terrible thing, and we obviously hope that it gets under control soon, and that everybody makes it through as in the best possible way. The other thing I wanted to briefly do before we get started is say a few words about George Priest. As I am sure everybody here knows, George died about a month ago after something of a long illness. He was a giant in the creation and development of the law and economics movement. And he was also a longtime friend of the Federalist Society and the longtime faculty advisor to our Yale chapter. Starting actually in 1982 when Ralph Winter was appointed to the bench, and until his retirement this past summer. So really very much, for the first 42 years of the Federalist Society. He was a man of remarkable creativity, intellectual honesty, and humility, and he will be greatly missed. One other brief announcement. The Wi-Fi password, which was selected not by us, but by the Association of American Law Schools, under whose general aegis this conference is being held, is Courage in Action, and that's all lowercase, but just in case anybody needs that. And then finally, I just wanted to note that we're delighted to be joined by the new president of the Federalist Society, Sheldon Gilbert. Who we look forward to leading the Federalist Society for the next 42 years. And for those 42 years to be even greater than the last 42 years. There are a number of other Federalist Society staff here. You probably have met some of them, but we all have these badges with a little red ribbon on the bottom, and please feel free to ask anybody with one of those badges for any assistance you may need. Okay, without further ado, let me briefly introduce our moderator, David Stras. Judge Stras currently serves as a judge on the United States Court of Appeals for the Eighth Circuit. He was previously on the Minnesota Supreme Court, and before that, he was a member of the University of Minnesota Law School's faculty. And he still does a little teaching there. There are many more things I could say about David, but in the interest of maximizing the amount of time we can spend on this very interesting topic, I won't lay those out, and instead I will turn things over to him to get the panel started. Thanks very much.
Thank you, Lee. So first of all, I want to say it is great to see so many people in this room. When I was a law professor, let's see, almost 15 years ago was the end of my tenure at Minnesota, we would get together, the Federalist Society professors would get together, and I think there was maybe sometimes 10 or 15 people in a room, and obviously we have, there's a lot greater numbers now, so it's really nice to see people who are Federalist Society, who are not Federalist Society, who are really interested in the topic. Just to see so many people gathered in this room is heartwarming. It's also nice personally for me to be back because I loved my time as a professor, and I don't get enough time to sort of interact with those people. The intellectual part of being a law professor is a lot of fun. Before we start, we're going to have a robust debate, I hope. But before we start, I just wanted to mention that I do have experience with this topic. I am not an expert in international law. But one of the things I did get to do was I got to visit Israel with a group of 14 other judges last March. And there's a number of judge trips that have happened since. And so I am going to draw on that experience as I ask questions. It was a fascinating trip, and we got to hear from folks from the Palestinian side, Palestinian leaders, as well as Israeli leaders. So it was a great trip. But I'm going to let them do most of the talking because they're the experts in the field. The way we'll do it is each one of them will give between 5 and 8 minutes of opening statements. Then I will ask a series of questions, hopefully spurring greater debate. And then at the end, if we have time, I'd like to open it up to the floor. The only thing I would ask is that you don't give speeches. You can lay out briefly any kind of background you need, but ask a question so that we can move things along and get as many people as possible to ask questions. All right, so our first speaker is over to my far left. It's Chimène Keitner, who is a professor at the UC Davis School of Law. I just want to mention a couple of things that are relevant to this topic. She has a doctorate in international relations from Oxford, where she was a Rhodes Scholar. She's a leading authority on international law, 27th, counselor on international law in the U.S. Department of State, and serves on the ALA's project on the fourth restatement of foreign relations law. So without further ado, I will hand it over to her.
So thank you very much for inviting me to speak today. I initially declined the invitation because I was concerned that the idea of a debate did not leave sufficient room for nuance. That's why in your programs it's labeled a discussion. However, I think it is commendable for the Federalist Society to focus on international law and institutions, and so here I am. More than 460 days have passed since the horrific attacks by Hamas and Islamic Jihad of October 7th. The physical and psychological toll on Israelis, including my close friends and family there, is undeniable. Today, we've been asked to focus on Israel's response. Members of Benjamin Netanyahu's extreme right-wing government explicitly advocate territorial annexation and deny any right to Palestinian self-determination. As we speak, the Israeli army is forcing residents of the northern Gaza Strip to move southward and requiring them to relinquish their personal belongings, including clothing, despite freezing temperatures. Israel has destroyed 70% of all sewage pumps and 100% of all wastewater treatment plants in Gaza, compounding extreme water shortages and contamination of the dwindling water supply. Nearly 1 million Palestinians lack emergency shelter. U.S. and foreign aid groups have documented Israel's systemic obstruction of humanitarian aid into the Gaza Strip. U.S. doctors and healthcare workers estimate that 120,000 people in Gaza have been killed by bombing, starvation, and disease. I believe that Israel has a right to use force in self-defense after October 7th, which is not a view shared by all international lawyers under the laws of occupation. I also believe that many, if not most, IDF soldiers and commanders are committed to defending their country within the confines of international humanitarian law. but that does not negate the risk of genocide by other state actors or the foreseeable destruction of Palestinian life in Gaza through the cumulative effect of attacks with tenuous or pretextual legal justifications. This is the crux of South Africa's case. So I have three main points. First, Israel has consented to ICJ jurisdiction over allegations of genocide, including incitement to genocide and failure to prevent genocide. In March 1950, Israel ratified the Genocide Convention and agreed that disputes arising under the convention could be adjudicated by the ICJ. Any party to the Genocide Convention can seek to enforce it. The convention obliges states to prevent and punish genocide and incitement to genocide. Genocidal acts include killing members of a group, causing serious bodily or mental harm to members of the group, and deliberately inflicting on a group conditions of life calculated to bring about its physical destruction in whole or in part. Palestinians in Gaza are a protected group under the Genocide Convention, and Israel has indisputably committed prohibited acts, the actus reus of genocide. Unlike crimes against humanity and war crimes, genocide also requires specific intent. The mens rea for genocide requires the intent to destroy a protected group in whole or in part as such. When South Africa instituted proceedings before the ICJ, it asked the court to enjoin Israel from pursuing its military campaign in Gaza. The court declined to do so. Instead, it ordered Israel to, quote, take all measures within its power to prevent the commission of all acts prohibited by the Genocide Convention and to ensure with immediate effect that its military does not commit any of the prohibited acts. The vote on that measure was 15-2 and included judges from the United States, Australia, and Germany. On a 16-1 vote that included the Israeli judge, the court further ordered Israel to take all measures within its power to prevent and punish incitement to genocide and to enable the provision of urgently needed basic services and humanitarian assistance in Gaza. On March 28th, the court indicated more specific humanitarian measures to address widespread starvation. And the Ugandan judge, who had voted against the first order, joined this part of the second order. This was not a divided court. A third order followed on May 24th. It cautioned that a military offensive in Rafah, where over 1 million displaced people were sheltering, could unlawfully create conditions of life that would bring about the physical destruction of Palestinians in Gaza in whole or in part. This leads to my second point. Palestinians in Gaza have a plausible right to be protected from violations of the Genocide Convention. Now, we can discuss the requirements for provisional measures in the Q&A, but in short, it would have been anomalous for the court to not to conclude, as it did, that at least some of the rights claimed by South Africa and for which it is seeking protection are plausible. Genocidal intent can be ascertained through statements and inferred from actions. At this preliminary stage, the court only needed to determine that Palestinians in Gaza faced a plausible risk of violations of the Genocide Convention, including a failure to prevent and punish incitement and a failure to prevent a serious risk of genocide. As a doctrinal matter, a war aim of self-defense can coexist with the commission of acts that violate the Genocide Convention. The two are not mutually exclusive. Likewise, some degree of compliance with international humanitarian law does not negate the possibility of genocidal intent. Actions by Hamas also do not absolve Israel of the legal obligation to distinguish between civilians and combatants and to ensure access to humanitarian aid. And that brings me to my third and final point. There is an emerging consensus that Israel is responsible for inciting, failing to prevent, and even committing acts of genocide. Israeli authorities announced their intention to deprive the entire population of Gaza of necessities after October 7, 2023. Their actions have rendered much of the Gaza Strip uninhabitable, and no place there is safe. Members of Israeli society and long-term supporters of Israel are issuing a wake-up call about Netanyahu and his ministers that I hope people in this room will hear. They are using the term genocide. Amos Goldberg, a historian at the Hebrew University of Jerusalem, writes, if you look at the overall picture, you have all the elements of genocide. A radical atmosphere of dehumanization of the Palestinians prevails in Israeli society to an extent that I can't remember in my 58 years of living there. Dr. Lee Mordechai, also of Hebrew University, recounts that high officials in the state and military have allowed local commanders to act as they see fit. They've approved policies of starvation and systematic attacks on hospitals while purposefully maintaining some level of deniability. Omar Bartov, an Israeli-American professor of Holocaust and Genocide Studies, has chronicled Israel's systematic attempt to make Gaza uninhabitable, as well as to destroy all institutions that make it possible for a group to sustain itself. These are not extreme or anti-Israel voices, and they are worth paying attention to. I want to see the hostages released, livable conditions restored in Gaza, and a degraded Hamas unable to recruit new members or mount violent attacks. If the Israeli government shared these goals, it would be acting very differently. I look forward to our conversation.
Thank you, Professor. Our other speaker is Sam Estreicher from New York University School of Law. He clerked on the Second Circuit and on the United States Supreme Court for Lewis Powell. He teaches a seminar in international law and has published dozens of articles and several books on topics relating to international law. And a tidbit is he is my part-time boss. So you're saying, how can that be? You're a judge. Well, I teach at the Appellate Judges Institute in New York that he runs the center. It's affectionately known as Baby Judge School for appellate judges. So I'll hand the floor over to him.
Thank you, David. I want to thank David for moderating this session and Lee Otis for her tremendous work for the Federalist Society, and Professor Keitner for being here as well. I've got to give you some priors. My parents were victims of genocide, and genocide, as was understood in the Genocide Convention, is about the systematic killing of a people for no reason at all. Not because they're in a civil war, not because they're located near civilian facilities and end up being damage not intended, but killing these people for no reason at all. My grandfather has to show up in Miechov, right outside of Krakow, to be killed. That's what genocide is about. And I grew up in a displaced person camp in Germany, where my parents were ferried, my father from slave labor camps from Germany, and my mother from Auschwitz through the forced march. That's what genocide is about. Now, look, Israel has made a lot of mistakes here. I'm not here as a defender of Israel. The widespread devastation in Gaza is a function of the way Hamas has fought this war. This was unprovoked, a long-planned attack on 1,200 civilians and then hostages taken and not released. Gaza was once a self-sufficient area, even under the PLO, it was self-sufficient in food. It actually exported food. Hamas, after about 2 years, decided to invest all of its resources in the building of these tunnels, an unbelievable network of tunnels, so they can protect themselves and use the Gazan people as hostages. I'm sure mistakes were made in this war by Israel. Israel does a lousy job of defending itself. Let me say a word about widespread starvation, which Professor Keitner mentioned. Israel has actually shipped, until January 1, from the beginning of these hostilities to January 1, 1,208 million tons in humanitarian aid. About 79% of it is food. We know from news accounts that the food is not getting to the Gazans, and there are lots of reasons for it, most of it on the Gazan side. Most of it on the Gazan side. What's the problem? There's the Hamas, which wants its cut, wants to control this food supply. There are bandits everywhere. Even our president with his peer, an attempt to set up a pier, faced the same thing, but did not want to use ground troops. And so they had trouble warding off the bandits. So banditry is a big part of it. The aid organizations do not want to hire guards to protect these convoys because they fear that Hamas will kill them. There are disputes over counting. The United Nations folks say they're not going to count halfway trucks that are only half filled. Israel wants to make sure that these trucks do not have any equipment, military equipment, and that sort of thing. So they don't count as trucks getting across to Gaza. This is all part, I'm afraid, of a kind of public relations activity on the part of Hamas and its allies. I'm not saying that the International Court of Justice is badly motivated. I'm saying that our view of this conflict has been molded by an unbelievable coalition of aid organizations, the UN agencies which have been suborned by the Palestinian cause and Hamas and the PLO, and by news organizations. Now, war creates a cloud, there's no question about it, the fog of war, but the fog here is really impenetrable. So that's why I gave you the example of the food. Let me say a few points about provisional remedies. By the way, I think Israel could have done more to protect these trucks. So do I think the aid organizations can do more. This is actually an implementation problem. We should not be talking about violations of the laws of war or genocide. We should be talking about how do we get the food to the Gazan people. This is an implementation issue, and that's the way it should be handled. If Israel's not doing enough, it should be doing more, and that's where the criticism should be laid to Israel and to the aid organizations. Let me say a few words about the so-called World Court's ruling, the ICJ's ruling. First of all, its jurisdiction here is limited by the Geneva Convention. Now, Chimène read to you the language. I want to read it to you again. The Genocide Convention is limited to acts of genocide, whether committed in peace or in war, and they involve various illegal acts, but they're only illegal under the Genocide Convention. Some of them involve killing of human beings, causing serious bodily harm. They're only illegal under this convention if they're done with genocidal intent. What does that mean? That means the intent to destroy a group or substantial part of a group because of their ethnic or religious identity, and for that reason only. It's a specific intent crime. So to loosely use language of genocide when you have not even made a showing of genocidal intent is wrong, and that's one of my concerns about the way ICJ goes about business. It is a specific intent crime. Even the ICJ agrees at the end of the day, if you're trying to draw inferences from a pattern of conduct, you have to show that the genocidal intent is the only reasonable interpretation of that conduct. Again, what is genocidal intent? It is the intent to kill members of a group because of their religious or ethnic background for that reason only. For that reason only. Now, you may say that's narrow. That's the purpose of the Genocide Convention, and that is why the Genocide Convention has been subscribed to by so many countries. Another point. So I disagree with Professor Keitner when she says Israel has committed prohibited acts. It has not under the Genocide Convention. The intent has to be proven, and I do not believe that Hamas or its interlocutor in this case, the human rights regarding state of South Africa, can prove genocidal intent, nor are they required to prove genocidal intent. The Geneva Convention is not an all-purpose mechanism for dealing with laws of war violations. The laws of war are nations have to abide by, including Israel. There's a lot of flexibility in the norms of the laws of war, but it's not the office of the ICJ under this convention to be adjudicating laws of war violations. The rulings of the ICJ are about provisional remedies, provisional measures. There's nothing in the statute of the International Court that makes provision, it does make provision for provisional measures, but it doesn't define it. It doesn't define the standard for provisional measures. It doesn't define what the scope of these provisional measures should be. The ICJ says it does have this authority to issue or indicate provisional measures. The question is, what is the standard for these provisional measures? You need to do something in the interim before the ICJ can completely decide the merits. Now, in most common law systems and most civil law systems, we use something like, in addition to proving irreparable harm and proving urgency, we require a showing of likelihood of success on the merits. It's not a full-scale trial, but it is an assessment of the merits as shown by both sides before we issue injunctive relief or other provisional measures. That is not what the ICJ does. The ICJ has a standard that actually is considered a very low standard. It uses the language of plausibility. And it says, are the acts complained of by South Africa, quote, capable of falling within the scope of the convention? Well, of course they are capable of it, because the Palestinian and Gazan people are protected by the convention. But are those acts committed with genocidal intent? That is the question. The court concluded in its order of January 26, almost a year ago, that the facts and circumstances recited in its orders are sufficient to conclude that at least some of the rights claimed by South Africa and for which it is seeking protection are plausible. What does it mean to say that rights are plausible? What does it mean to say that rights as opposed to claims are plausible? That's quite interesting that the recently departed president of the ICJ, Joan Donoghue, had to go on the radio in a BBC interview and state that the court, quote, did not decide that claims of genocide were plausible. It did not decide that claims of genocide were plausible. Only that there was a risk of irreparable harm to the Palestinian right to be protected from genocide. Well, all have a right to be protected from genocide. The question is it more likely than not Israel has committed genocidal acts here? Genocidal acts meaning not just that people have been injured, because largely that's a function of the way Hamas has conducted its war. It conducts war near utilities for water and that sort of thing. The question is, are they doing this for the purpose, for the intent, with the specific intent to kill the Gazans, or to kill the Palestinians, if you will? The court says no plausible claim, never states that there was in fact a significant risk of genocide or why the genocide label is attached at all to these events. I mean, mistakes were made. Mistakes were made, but is it genocidal? What makes it genocidal? Because they say so? What is going on here, in my view, and I'm not attacking the good faith of the ICJ judges, but what's going on here, and this is applauded in the academic literature, is an attempt at actually getting at issues of the laws of war through the genocide label, through the label, without proving genocidal intent, or coming anywhere near to improving it.
Should we give Professor Keitner a chance to respond?
Sure. Am I past my 8 minutes?
Yeah.
Good.
Go ahead.
Thank you.
I'm actually quite happy to leave the floor to you, Judge Stras. I mean, I think that our presentations nicely highlighted the areas of convergence and the areas of disagreement. And Sam, I felt like a lot of, what maybe we could be arguing about is what I would call merits arguments, right? And for the benefit of everyone in the room, and Sam and I have both written online about this, so those of you who are interested can look at what we've written. There's also a panel tomorrow on the International Court of Justice and the Genocide Convention, again, for those of you who are interested in digging into the weeds. But I think, as Sam indicated towards the end of his remarks, we are at the provisional measures stage here. And so what I heard, and of course, correct me if I'm wrong, Sam, is more of a disagreement that Sam has with the ICJ's standard for provisional measures, which is a finding that there are plausible rights under the instrument that gives the ICJ jurisdiction, here the Genocide Convention. The Geneva Conventions govern the laws of war, and as Sam says, those are not within the remit of the ICJ's jurisdiction in this particular case. So this plausible rights idea, where again some of the ICJ's terminology has veered into sort of a plausible claims terminology. Sam and I have both taught civil procedure for many years, and so with that hat on, we see plausibility and we think a certain thing, but in the international court, it is a fairly low bar, which is precisely why the court did not order Israel to halt its military campaign. And in fact, its first order essentially ordered Israel to comply with its existing obligations, both not to commit acts of genocide, but also not to allow incitement and proactively to prevent genocide. So I think maybe that can help us sharpen the debate. We also do have a disagreement, I think, about the definition of genocide. I don't think it needs to be a killing of a group for no reason at all. There can be multiple intents that coexist with each other. But again, I want to leave enough time for questions. So those would be my 2 big points.
Go ahead.
Well, you can't have a standard for provisional relief that has nothing to do with the ultimate case you have to prove on the merits. The court did not even look at the vast range of humanitarian measures that Israel has taken, as I pointed out in the context of food. If you're going to say that there is a probability of genocidal intent, you've got to look at the entire picture, and that is not being done here. What did the court rely upon in its orders? It relied on 3 things. It relied on the extent of civilian casualties. To this day, we do not have an accurate count of those casualties because they're coming out of the Ministry of Health of the Hamas. Hamas counts its own militants among the civilian casualties. There have been periods when there seems to be a linear increase in civilian casualties. Seems unlikely. It's been criticized. So that's the first prong, the factual circumstance the court refers to. The second factual circumstance the court refers to is the reports of various UN agencies. Now, I'm afraid the UN agencies have completely lost their legitimacy, many of them, in reporting on this stuff. And the third thing are these so-called incitement statements. There is no question that at least three of the Israeli leaders, one of them is Gallant, the deputy prime minister who's no longer with the government, they said things that were overblown, in my view, very early in response to the massacres. Gallant himself has been a key figure in trying to provide humanitarian aid to Gaza. We do not have widespread incitement to genocide. And in fact, the court doesn't even say that. And that's important. I think that's important because where you don't have official widespread incitement, you do have to show that genocidal intent is the most reasonable inference you can draw from the facts. That's from the court itself in an earlier decision. Thirdly, well, that's about, so the point is there has to be some connection. That's my problem. It's not a quibble. It leads to a situation where the word genocide is bandied about, and it's now being bandied about worldwide. Bandied about worldwide, where in fact, I don't think there's a plausible case here of genocidal intent. If I thought there were, I'd feel differently about this case. And Israel could do more, but even on the water situation, the utility situation, why are some of these utilities being injured? Because of the way Hamas has located its fight. And that's the point of it. Mao Zedong said long ago, you swim among the fishes. By swimming among the fishes, the army you are fighting will kill the people, kill the fishes, and then we'll build support for our cause. And that's basically the Hamas strategy. They violate almost every single law of war. I'm not justifying everything Israel has done, but that's where the fault lies for the widespread damage to the civilian economy in Gaza. What needs to be done now is practical, problem-solving people. Let's figure out, Israel claims it's done various measures with respect to the utilities and the sewers and that sort of thing. Maybe it's not enough. Let's get concrete about what more needs to be done. And let's figure out a way of protecting the food supply from the bandits that are out there. It's a kind of Mad Max environment.
I want to start at the beginning. Being an old criminal law professor, there's an interesting question. One point of agreement between both of you is that, and actually U.S. foreign policy as well, is that Israel has every right to defend itself. It has that right. And I think where the disagreement comes just at a basic philosophical level is at what point does a country cross the line, if ever, in exercising that right of self-defense? And what do you do in a kind of a compound question? What do you do in a situation in which both sides want to eliminate the other?
So international law has come a long way since Mao Zedong. Thank goodness, right? Thank goodness. I think the right to self-defense under the UN Charter is not unlimited. I don't think, but Sam will let us know, that either of us would suggest it's unlimited. If Hamas were hiding out in the basements of Washington, D.C. row houses, maybe they'd compelled the owners of those houses to let them hide out in those basements at gunpoint. We would never say that it's consistent with the laws of war to obliterate Washington, D.C. Now, we said that we would sort of not dive into international humanitarian law, and so I'll leave it at that. But there is a point at which willful ignorance, let's say, even setting aside the incitement, and again, there I am quoting from Israeli historians, academic scholars, lawyers, in indicating the degree to which, I mean, just look at the top, songs on the pop charts in Israel and the lyrics to those songs. Even Haron Barak, the judge ad hoc from Israel, agreed in the first provisional measures order that incitement needed to be prevented and punished, and he voted with that order. So again, I think our job here today is not the more difficult job of figuring out how the court should rule on the merits. It's the job that, again, I will freely admit, I was more skeptical of at the outset of this conflict, which is the job of saying that there is a plausible risk of genocide and that there is an increasing consensus that that risk has materialized. And I think that's where I am. Other Israeli-trained lawyers, Itamar Man, Aryeh Meir, have also moved in terms of their views. And the reason I say that is because I agree with Sam that there were people who were too quick to jump on the genocide label. I think it would be used in public discourse regardless of whether or not the ICJ issued a provisional measures order. I think that word is out there, and it is bandied about in different circumstances, but just because that's the case doesn't mean, I think, that we can dismiss it out of hand when it hits closer to home.
Do you have a response?
Well, I do think that the right of self-defense for a nation is virtually unlimited. That doesn't mean you do crazy things, and if you've agreed to certain limitations on the means you used, I believe this country would, and it has, by the way, even when the threat to this country was less than the threat that Israel has faced, by insisting on unconditional surrender by both Japan and by Germany. Now, I'm not saying that Israelis have a right to kill civilians because they're civilians. They do not have a right to use instruments that do not try to minimize the risk to civilians. Absolutely, that's part of what any humane nation should be doing. That's not what Israel's doing. Hamas has created this problem because Hamas, it may be the international law has gone way ahead of Mao Zedong, but actually they're privileging this form of asymmetric warfare. And for some reason, the public international community actually wants to further it. I don't know why. And in the Israeli case, the demons have captured the public imagination of many of the international lawyers. Maybe that'll change, who knows, but that's what's going on here. You don't have a right to sort of willfully kill civilians, but you have a right to defend yourself, and if there's a serious risk to your security, you have a right to try to eliminate that risk and not have the international organizations micromanage how you are dealing with that risk. If there are laws of war violations, then I'm sure they'll be taken up in the ICC prosecutions, they'll be taken up in public debate, they'll be taken up by nations in their dealings with Israel. The problem here is we are linking what may have been some use of indiscriminate force, maybe, I'm not conceding it, but certainly mistakes have been made, the failure to explain what has been done. We're linking that to a risk of genocide. There is no risk of genocide. The population of Gaza is one of the fastest growing populations in the world, according to U.S. population statistics. I'm not minimizing the strife that occurs in Gaza. That strife is largely a function of the way Hamas has conducted this conflict.
So along those lines, one of the things that struck me, and I think most of the judges that were on that trip last March, is just how complicated the conflict is, particularly after what happened on October 7th and in the intervening time. You have two competing cultures with very different values, that have a history of not getting along and even being at war to a certain degree. And then you have a court like the ICJ that really isn't all that familiar, from what I can tell, with the culture of each one of these communities. And so what is the legitimacy of the ICJ? Like, how can the ICJ possibly come to a conclusion not really understanding what's going on the ground?
Want to go first?
Well, they should have a standard for provisional remedies that actually takes into account the entire situation and puts the applicant to the burden of showing some connection between the harms that it's seeing and its ultimate proof, what it ultimately has to prove for there to be a violation of the Genocide Convention. I think there is a limit to what law can do here. I mentioned the fog of war. It's completely occluded at this point. There's a limit to what they can know, but the problem is they have too lax a standard. Every commentator on the ICJ jurisprudence, whether they're in favor or not in favor, says the extremely lax standard. And even the former president of the ICJ had to get on BBC to explain that not even the claim of genocide was plausible. So why are we talking about genocide? We should be talking maybe about preventable acts, preventable obstacles, that Israel should undertake, and putting Hamas to the test of being a responsible warrior, which it is not. In any event, maybe that's Pollyannish on my part, but this is, I'm not saying this is the motive of the judges, but this is part and parcel of a program of lawfare against Israel to delegitimate it, to enable the Hamas and the other proxies of Hamas in Iran to continue doing what they are doing.
I'll have to go back and reread the ICJ's orders more carefully, but I'm pretty sure none of them say that Hamas should keep doing what it's been doing. In fact, I'm pretty sure that each and every one of them calls on Hamas to release the hostages. The reason, as we've explained, that we're talking about genocide today is because we're talking about the proceedings in the International Court of Justice. Now, Israel could have given the International Court of Justice jurisdiction to adjudicate war crimes and crimes against humanity. But like the United States, it has not. So the fact that we're litigating under the Genocide Convention, which does put constraints on what the court can do, is because of the consent-based nature of the court's jurisdiction. Now, Judge Stras, as you mentioned, this is an international court, which is particularly fitting when we're talking about implementation of international law. Sam mentioned the International Criminal Court, which is also seized with this matter in a different way. That, too, is an international court. And in fact, far from lacking sufficient insight into the nuances of the conflict, these are, and I'll talk just about the ICJ now, these are bodies that have the imprimatur of the UN Charter, from which judges, including, as you mentioned, the United States, on which judges who've been elected by the Security Council and the General Assembly sit, and they've issued these orders after hours and days of both oral presentations, written submissions, and the submission of evidence, including in Israel's case, a video that the judges watched that I am grateful not to have had to watch about the atrocities committed on October 7th. And so while I was very concerned at the very outset of the war when some groups came out and said, you know, this is not a complicated situation, it's very clear-cut, right and wrong, Hamas is in the right, Israel's in the wrong. Nonetheless, I would also very strongly come out against the notion that, oh, this is just so complicated, it's the Middle East, we can't say anything useful here. To the contrary, this is exactly why we need to be saying something quote-unquote useful here. This is exactly why we need to be applying legal standards. And 460 days after the war started, if there is a fog of war, it's because journalists are not being allowed into Gaza. And journalists in Gaza have been killed, deliberately or not, as part of this really overwhelming use of force whose self-defense justification is increasingly difficult to see.
I want to help folks, and you mentioned this, both of you mentioned this briefly, but the plausibility standard. As many of you are aware, I mean, our experience with plausibility comes from Iqbal and Twombly, right? Is it a plausible case? My own experience tells me, many of those cases that are plausible at the time of a motion to dismiss don't get proven at summary judgment or at trial. And so I'm wondering, just because I don't know that journalists really understand what the ICJ has decided, what, in your view, does international law say about this plausibility finding? How significant is it, and what does it tell us?
That's Chimène.
Yeah, I've spent more hours than I can count in the past year and a half trying to explain this to journalists, but doesn't mean they always get it right, and they don't get it right with U.S. law either. Look, Mike Becker has a great piece forthcoming in the Melbourne Journal of International Law on plausibility. I highly recommend it. Sasha Greenewalt has a new piece coming out on intent and the drafting history of the Genocide Convention. There's a lot of great work that I commend to all of you. I would say, and this is something I've grappled with, right? In the U.S. system, preliminary injunctions require a showing of likelihood of success on the merits. Plausible rights are nothing near that. Now, if we were talking about, as South Africa proposed, in joining Israel's entire military campaign, I think plausible rights are a fairly thin reed upon which to do that. Mind you, the International Court of Justice not long ago did precisely that in enjoining Russia from continuing its military campaign in Ukraine on the basis of provisional measures under the Genocide Convention. So if we're looking for consistency in jurisprudence, we can't say, you know, one set of rules for Russia, another set of rules for Israel. But that being said, the measures that have been ordered are extremely conservative. And so even if we're concerned about overreach, when we look at the actual measures ordered, and Israel, by the way, has been submitting monthly compliance reports with those measures. So although those compliance reports are not in the public domain, the measures are geared towards ensuring compliance with the Genocide Convention. And to my mind, when those are the measures we're talking about, a lower plausibility threshold than we have for preliminary injunctions in the US legal system is much less problematic.
I agree with that. However, there needs to be some connection between the harm you're complaining about and your ultimate burden on the merits. And that requires you to consider what is the basis of the evidence for believing there's genocidal intent. There's nothing on genocidal intent in the ICJ orders other than the quoting of these three folks, one of whom is Gallant, one of whom has actually been very actively involved in the humanitarian food effort in Gaza. At the cusp of this terrible massacre, all of us might have said things we shouldn't have said. There is no widespread incitement. Songs, I have not heard the Israeli songs, but we have terrible songs in this country on how we talk about women and rape and that sort of thing. I hate to have that ascribed to the national state. I think there's a problem here. There are limits to the Genocide Convention. You can see this in the literature that is burgeoning now by academics. They want to get away of addressing laws of war issues, which are very malleable, very flexible, very unpredictable, through the Genocide Convention, because they have countries like Israel that have agreed to the ICJ's jurisdiction here. It should be resisted. The remit of the court, as Chimène has acknowledged, is limited. They have to show that these acts are occurring. I don't think that any reasonable person looking at the degree of humanitarian efforts that Israel has undertaken, not perfect, can say that there is a basis here for genocidal intent. And that is why, in fact, that is not what the ICJ found. The fact that they were rejected in a completely unfounded attempt to stop the conflict in Gaza on this showing doesn't say anything except the absolute obvious that would have brought the court into disrepute. And I actually think to some extent it should be brought into disrepute even now, because it's banning about the word of genocide. It has no basis for saying it. It is saying it for other reasons. I don't know if that's the motive of the court. That's how it's reasonably being interpreted worldwide, including the former Prime Minister of Canada and other people, because they're just getting a blimp in the news. You go to Google now and you try to find out about the food situation in Israel, you get 300 media people all repeating themselves. And I asked, what is the Israeli claim here? You can't find it out from Google, because there is a kind of media, I don't know if it's conspiracy, but there's certainly operating in concordance with a narrative. And the narrative is that Israel is a delegitimate state, and it's not allowed to defend itself. And defending itself means extirpating the threat as well. If we were ever faced with that domestically, believe me, Israel would look like a knight in shining armor to what the American response would have been.
Can I just add two fingers on that? And unfortunately, under the incoming administration, I might not disagree with your last statement.
That'll be true under Biden as well, by the way.
The laws of war are not malleable and unpredictable. Our Defense Department has actually many more lawyers than does our State Department, who are tasked with interpreting, applying the laws of war. Again, as you mentioned, that doesn't mean they're always interpreted perfectly. That doesn't mean there isn't room for disagreement in certain areas. But I would certainly not dismiss the entire field as malleable and unpredictable.
I think it's prone to those problems.
Sam, I didn't interrupt you.
I think you didn't.
I also think that the suggestion earlier that we didn't really dig down on about these are two incompatible cultures, I do want to push back on that. I think Sam has pushed back on that. You've got some really interesting writing about how Israel should more inclusively recognize its Arab citizens and include them in the civic life of the nation. And so I just wanted to not leave that out there because I actually don't think it's true. I think there's a lot of mutual misunderstanding stoked by certain figures in power, but that does not mean that there are two incompatible cultures. And as for the word genocide being bandied about and no reasonable person could use it, I would just indicate again, this was not a divided court. These are extraordinarily sophisticated jurists, and the decisions were issued by an overwhelming margin, and so you don't need to take my word for it. On the facts, well, Meta's not fact-checking anymore, but again, it actually is not that difficult to find both Israel's numbers, and all of the numbers I provided were very specifically from US-based groups, so that we have some sort of sense of, impartiality to the extent that that's possible.
All right, you had one more thing to add, Sam?
Look, if you want to be in the international law field, you have to go along with the ongoing narrative. That's what we're seeing right now. Justice Barak agreed to one of the provisional measures because he said Israel already is required not to engage in genocidal acts. That's what he said. Because there's something anodyne about as Chimène pointed out, about some of the provisional orders. The problem is it's linked with the language of risk of genocide. And genocidal intent, in my view, cannot plausibly be proven here, and certainly requires a consideration of what Israel has done on the humanitarian side.
So suppose this goes forward. I just want to look to the future. The prosecution or the ICJ proceedings go forward. There's another adverse ruling of some kind. I don't know what that looks like, but you could tell me. Against Israel, what enforcement mechanisms does the ICJ have? And what happens if Israel just decides, we think this is an unjust ruling and we're not going to follow it?
Well, Chimène can speak to this if she wishes. I think Israel will face some adverse reaction from other countries, for sure. The UN can decide to proceed. Maybe it'll be part of the fodder for the ICC prosecutions. Maybe some countries will decide that they need to boycott Israel. I mean, I think that's where any coercive measures will be. That's why it's so troubling that the ICJ has used language of risk of genocide. If they had said Israel can do more to alleviate these problems, I would have favored that. Should do more. But the problem is there's a limited remit in this convention, and that's why the ICJ has to talk about risk of genocide.
Chimène?
Well, enforcement with international law and institutions is a whole semester course at least. Let's just say that I think the best we can do is lead by example. And if indeed the court's decisions are alienating people like Sam, who otherwise would be more vocal supporters of putting more pressure on the Israeli government to follow through on its humanitarian aid commitments, not to let extreme right-wing demonstrators at entry points into Gaza block trucks from going in, not to empower ministers like Ben-Gvir and Smotrich to have control both over national security policy and domestic policing. If we could assemble a constituency, which is also why I'm up here, not just because it's letting me procrastinate from grading my civil procedure exams. If we can assemble a constituency that can look past these deep-seated emotions around the term genocide and recognize that the degree of human suffering in Gaza right now, whatever its causes, is fundamentally unacceptable. This is a conclusion that lawyers in the State Department have reached in memos that have been published in the press, indicating that under the US's own laws, certain arms shipments to Israel violate our obligations not to be potentially complicit in serious risks of international humanitarian law violations. This is a situation that does very deeply affect those like Sam, like some of the people I quoted who have direct family experiences of the Holocaust. But I think we need to decide, is genocide a label only that will apply to putting people in gas chambers? Or, as its creator, Raphael Lemkin, intended, will it extend more broadly to include instances where there may be multiple motivations, states are not monolithic, there may be different actors within the state, some of whom have annexationist and eliminationist impulses and goals, others of whom don't, yet others who within Israel are not being shown what is certainly not propaganda, but what is actually the facts on the ground, video footage of the degree of devastation. Can we get past those emotional gut reactions to a place where we say that this is not acceptable?
So that's actually a great segue to audience questions. And the reason why it's a great segue is because people have strong feelings about this issue. And that's not the purpose. The purpose is to ask questions of our panelists and not to give a speech. So I would just ask that people keep it brief and actually ask a question. We'll go over here to the left first.
Hi, thank you so much. My name is India Tusi. I'm a professor at Indiana University Maurer School of Law in Bloomington. So my question is going to the mens rea component, particularly to the arguments that I guess Professor Sam was making. And you stated that to establish genocide, there has to be a killing for no reason at all other than the killing of this population. So the way I'm conceptualizing this, then, for specific intent, you need to establish the killing of a population in addition to that no other reason. However, I'm struggling to think of any genocide that doesn't have an additional articulated reason. So take, for example, Rwanda, where you have the Hutus who committed a genocide against Tutsis. They had reasons to try to kill this population. They stated that this population was engaging in corruption. There were rumors about them trying to exterminate them. They said that they were stealing resources. They described them as cockroaches. And I think this is consistent. There's always an articulated reason for it. So if we have this additional requirement that specific intent is not just to target a killing of a population, but there can't be another reason for it, I'm really struggling to imagine any situation where you would be able to establish genocide. So I'd like to hear a little bit about that.
Well,
Thank
in
you.
response to your point, I was saying that was actually what the Nazi situation was. There was no other reason for what they were doing. Now, if in fact you want to kill these people, and you have lots of reasons for killing them, I think that would be sufficient to prove a genocidal intent. But the intent was not to kill these people as such because of their background. There are mistakes being made, perhaps, maybe excessive use of force. That's what I mean. And the ICJ itself says at the end of the day, to prove genocidal intent, you have to prove that the only reasonable inferences you can make from the evidence that was the intent of the people acting. So I agree with you. It's just if you're killing these people and you're killing them for a variety of reasons, but you are in fact killing them, that's your purpose, that's sufficient.
Okay.
All right, let's move over here next. Rob?
Just so you're out of the camera shot for these guys.
Oh, we're having to move the microphone, I think.
All right. Robert Leiter, Ann Scalia Law School. Two questions, both brief. First, what, if anything, differentiates how the IDF has prosecuted the war in Gaza from how Russia has fought in Ukraine, or how the belligerents in the Syrian civil war have fought, that justifies the disproportionate attention that Israel has received at the ICJ and from the international community? And second, I see in a lot of these debates, they are internal to how some academics understand international law and the laws of war. And if this is the direction that we're going, are these legal systems becoming so detached from the norms of justice that they're going to lose whatever legitimacy that they have?
Chimène?
So on the attention, I think it's a function of the consent-based jurisdiction of these institutions. The ICC is investigating Syria. Canada and the Netherlands have just brought an ICJ case against Syria under the Torture Convention. Ukraine has brought multiple cases against Russia, both under the Terrorism Financing Convention, the Convention Against Discrimination, and the Genocide Convention. So it may be that media attention most recently has been focused on Israel, but it's absolutely not the case that other international institutions aren't addressing all of the conflicts you enumerated. As for legitimacy, I think that is an extremely important and interesting point. It's one that we could probably discuss for hours after this event, but I think fundamentally, many in this room would also have different ideas of justice in this context, the way that you're invoking it, which is precisely why we try to adhere to enumerated rules and standards that countries have agreed to.
Just a word on consent-based. Not everything the ICC does is consent-based. Israel has not agreed to the Rome Statute, neither has the United States. And I'll make a short-term prediction for you. Israel and the United States will be the principal subjects of scrutiny by the ICC. In the case of Israel, they have added Palestine as a state, so that, in fact, what goes on in Palestine, which is not a state at this point, nor responsible, so that activities that go on and actions that go on there can now be the subject of ICC scrutiny. Early on, I was involved with a group of experts in trying to convince the prosecutor they had no jurisdiction, but now the Rome Statute has been changed, so now there is jurisdiction. So it's not quite consent-based, and my argument about the Genocide Convention is because the way we are framing these provisional remedies, we are in fact adjudicating laws of war issues under the guise of genocide.
All right, go ahead.
Thank you. Stephen Sachs, Harvard Law. I do Civ Pro and not Law of War. And so
You
I
can
was,
really change constitutional law in this country, Stephen.
from your mouth to God's ear. But but my question is, if you could, as a non-expert, walk me through something like Sherman's March to the Sea. My understanding is that the ostensible purpose was to destroy all public property of value to the enemy. The sort of less explicit purpose is to show the futility of further resistance. How would that be handled under modern law of war and under the Genocide Convention if it happened today?
It's a great question. I'm going to give that to Chimène.
So again, many hours of fruitful conversation. I don't know enough about the writing, for example, around the time of the march. You know, we would look at what in fact happened, the actus reus. For the mens rea, we would look to public statements in diplomatic correspondence, military correspondence, and so forth. It's a fact-intensive
Things like
inquiry.
the Battle Hymn of the Republic, talking about crushing the serpent beneath your heel and so on.
Again, as our former speaker mentioned with respect to Rwanda, there are times in which dehumanizing language, like calling another group cockroaches, is very much an indication of the dehumanization that allows an inference of genocide. In Srebrenica, the massacre of 8,000 men and boys, even though that did not extend to women and children, was deemed a genocide. So while I'm not prepared to make, again, absent all of those other, my historical knowledge is not as great as yours, I think you would use the same kind of analysis on the merits, and it is very possible, particularly I would say with respect to indigenous populations in North America, that many genocidal acts occurred prior to the UN Charter system being put in place.
Under the current international law as it's interpreted, what we did in Japan and with respect to Germany would have been viewed as violations of international law by insisting on unconditional surrender and subjecting civilian populations to the harms that they endured.
But again, just to put an asterisk on that, 100% violation of the laws of war, the further question about genocide is this fact-intensive inquiry that, as has been pointed out, does have this additional mens rea requirement.
Thank you.
All right, let's go over here. This may end up being the last question because we have a hard 1240 cap to make sure we don't
No pressure.
overlap. Yeah.
John Dane, Loyola University Chicago School of Law. My question is whether we are looking at this through the Genocide Convention when what we're really dealing with is a use ad bellum proportionality problem. Because as Sam said numerous times, the right of self-defense is not unlimited, but you get to eliminate the threat. well, if you set the goal as eliminating Hamas, then what you can justify as a matter of proportionality under the jus in bello, the IHL, as well as under the jus ad bellum, changes. And so the problem, as I see it, is that Article 51 of the Charter says a member of the United Nations has the right of self-defense in the event of an armed attack until the Security Council takes effective measures to restore international peace and security. And what is not happening in these and other conflicts is that the Security Council is not taking effective measures to restore international peace and security, which leaves states in the position that they feel they have themselves to eliminate these threats to international peace and security. So does that somehow convert the genocide issue into really a jus ad bellum proportionality issue? Or how would you assess how that influences your views on what the ICJ has done? Thanks.
I'll leave that to you as well, Chimène.
So Gabor Rona has a piece in Lawfare arguing that you can be in perfect compliance with international humanitarian law and still be committing genocide. I don't go that far. I would acknowledge, as Sam has indicated, that when we're talking about armed conflict situations, there are converging bodies of law, and it is difficult when a court only has jurisdiction under one body of law and not the other. That said, this goal of eliminating Hamas is not necessarily a valid goal, even under the law of self-defense. Eliminating the threat posed by Hamas is a very different matter. As Sam said, and I wasn't going to raise this, but since he did, this attack could have been prevented. It was foreseen. That does not in any way take blame or culpability away from those who perpetrated it, but it does suggest that Israel felt secure, without the erasure of civilian life in northern Gaza and the destruction of most of the buildings in the rest of the enclave.
Any response, or?
Well, a lot was said by Chimène just now. I think there is a problem with the international law because, in fact, the Security Council cannot get into action here, so the states do look to their own. Again, I think if countries are going to agree to international treaties, these courts have to be limited to the terms of these treaties, and that will undermine their legitimacy. I believe that the ICJ here has undermined its legitimacy. Maybe not today, but over the course of time. So they have to take that into account. There is convergence among academics on a certain narrative. The academics are the ones that will fill the rosters of this ICJ tribunal, the ICC tribunals, and so there'll be a kind of green light from that convergence, from that consensus. But they have to take into account the fact that they need the support of some of the major countries in this world, including the United States.
All right. Well, thank you to all of you for coming. Sorry we have to cut off the questioning here. We had a very robust discussion that kind of meandered into a debate, but mostly a discussion, I think. But in the event, we owe a big round of applause for our panelists who did a great job.
Thank you to you. David, thank you.